And Jake has done a little bit of research for us, and this kind of refers to RSA 91A, which is for the public to be able to view what boards, committees, and so forth do in the state of New Hampshire. Basically, the way it's set up, at a meeting, public has a right to be present and has a right to take notes, has a right to videotape and everything, but it does not give them a right to speak. And when they can speak is during public hearing and also public comment. But the planning board, like the zoning board of adjustment, and to some extent the heritage commission, are land use boards, and they come under a specific criteria of RSA 673:14, which follows the juror standard. So I'll let you take it away there, Jake.
All right. So, I want to talk a little bit about a few issues we've had at past couple meetings. Work sessions are a very common item at planning board meetings. We use these work sessions as an opportunity to discuss items and form a consensus on what to present to the public. During work sessions, the chairman of the board does not accept public comment. However, there will be a time to comment when that item being discussed at the work session is brought forward, properly noticed, and turned into a public hearing. A public hearing allows members of the public to come forward and comment on whatever item that we may be hearing on. In brief, our public hearing goes as followed. Presentation from the board, staff input, input from the members of the board, and then last but not least, public comment. Examples of these most recent work sessions that have drawn attention from a few members of the public are the September 13th CIP work session, as well as the November 8th zoning amendment work session. At both meetings, members of the public had asked to speak. During the September 13th meeting, a few of the members of the public had asked to speak. The chair decided he would allow it, but after the presentation and the board's input. Allowing them to speak at that time follows the same order in which we would do it a public hearing. Public comment being last at the end of that presentation. A member of the public began to speak while sitting in their chair. After some time, I had asked the chair if she was to continue to speak, would they please come to the mic? At that time, they decided they were all set and no longer wanted to speak. One other member of the public had waited until the end of the presentation, and the chair had allowed him to speak, just as he would have at a public hearing, even though traditionally the chair does not allow comment at public sessions. There was a public hearing on the CIP there was a public hearing for the CIP, which was our work session, the following meeting on October 4th. As a reminder from my earlier statement, the public hearing is the time where the public can comment and voice their opinion on an item in front of the board. In this case, it was about the CIP. During the public hearing, there was one member of the public who commented, the chairman of the council. No other members of the public that were present at the September 13th meeting were present to speak on October 4th. I have to ask myself, if they wanted to speak so badly during the work session, why did they not stay until the conclusion of the presentation? More importantly, why didn't they show up to the public hearing? The November 8th meeting brought a similar situation to a work session with regards to a zoning amendment. A member of the public had asked to talk on the zoning amendment. I suggested to the chair that we follow what he has done in the past, which was to not allow public comment given the difficulties we had on the meeting of the 13th. There will be a public hearing on those proposed amendments. At that time, members of the public will have the ability to speak and heard by the board. I believe that public hearing is tonight, correct?
Correct.
In recent months, I have suggested that we adjust the planning board rules of procedure to reflect how the chair runs work sessions. These adjustments have yet to be made. After last meeting, I took some time to make potential amendments to our rules of procedures. Some of these amendments reflect procedures for work sessions, conceptual discussions, and adding a section of public comment to planning board meetings. I've forwarded my edits, as you all know, to the members of the board, so we can hopefully review them next week and start to look at changing some of our amendments. Kellie has a copy of those amendments, so I'm sure if there's anybody in the public that would like to see what my recommended amendments are, she'd be more than happy to give you a copy. But, that's really what I have to say about it right now. I think that a lot of the edits I've made are just to reinforce how we've had a meeting, in hopes that we can get through this issue we're having with public comment at a time where it's not warranted. I know some people are having trouble understanding that, but there's a reason for the process. And I look forward to talking about it a little bit more next week, once the board has had a chance to review all my edits, because I know I sent them a little later this afternoon. Any questions?
Well, I think you said it quite well. I guess the RSA 673:14 basically says that a member of a land use board, most of our function is quasi-judicial. So we have to sit as a judge and jury. So therefore, we have to be careful of information that gets filtered to us, because if we end up being accused of being biased, that means a member has to recuse themselves. If they don't, that could result in the town being taken to court. So people's property is a very precious thing to them, and they really guard, and I'm talking about their wealth, which is both land, investments, and everything. That's how the state of New Hampshire looks at property. And their property is involved. We deal with the property every single meeting. And people look at that very closely, and they can get very upset if something is being, their rights are being abridged due to their property. So what this really says, that any question in which a board is to decide, this is a land use board in a judicial capacity, if that member has a direct personal or pecuniary interest in the outcome which differs from the interest of other citizens, or if that member would be disqualified for any cause to act as a juror upon a trial of the same matter in any action of law. So basically, we act as a jury. So you know what the juror standard is. And if anyone is interested, I can refer you to RSA 500-A, and it explains jurors and examinations, and there's reasons there. And our attorney has advised this board that is exactly true. There's case law that supports it also. So that's why we don't have public comment.
And I'd just like to add, Mr. Chair, that, the reason we don't have public comment at work sessions are, to make sure that everybody gets a chance to speak. Our work session is a time where we come forward, the board or staff presents us something that we decide whether we want to have a public hearing or not. If it's an item that directly impacts your property, how would you feel if people were commenting about that and you were never notified about it? So it gives us the ability to have the proper notification process to make sure that everybody has a chance to comment on it at the appropriate time. So we do allow public comment in a process, and that process is used to protect everybody, not just the people that were at a meeting one night. You folks were probably noticed. That's why you're here. It's only the fair way to do it for everybody. And
So I think this, if I may, Mr. Chair, I think this might be a good time to while we're breathing fresh air, to say that our work sessions are put together because, just like the town council, we're not allowed to talk to each other or group email or
first
whatever.
time we all get to hear it.
The only chance we get is when we're here, when it's been noticed and whatever, that we can talk about issues, items, or land use issues or cases or whatever. And so that work session needs to stay, my opinion, one person's opinion, needs to stay sacred, so that the work can get done, because it's the only chance that we have in the course of our twice-a-month meetings. Very similar to what the town council encounters, because they're a 5-person board, they can't have 3 people standing in a room at the same time, and all kinds of crazy rules. So anyway, thank you. I thought it would be a good time to put that out there.
And the other thing, too, to note is not everything in a workshop is ever going to come before the public.
Right.
Yep. And I've had experience, this is a long time ago, the instance where the planning board was having a workshop session, they're talking about a piece of property that the landowner had no idea was being talked about, and was very incensed because three people were deciding what to use his property with. So that prompted really a good problem for the town. It took a while to resolve. It wasn't quite a court issue, but it was settled, so we don't need to get into arguments like that. But with a public hearing, all the abutters are noticed by certified mail, and also there's an official warning 10 days before the public hearing, where the public is warned about the meeting so that everyone knows. And that's fairness. That's also backed up by case law, so. Enough of this, we need a meeting to get to, and